Fulton Wasloan recall 580-561-562 and 563. And just waiting on my computer. Thank you for your patience.
Yeah.
1 sec, there it is. False statement to a public servant is the charge on 563, and driving suspended third degree is a charge on 562. And Mr. Waslum, if I'm correct, you don't want an attorney to assist you with arraignment here this morning?
I will be standing on as my own counsel.
Okay.
I've appointed myself as my own counsel, and I'm ready to proceed with administrative procedural matters.
Do you want to hear a formal reading of your rights?
Sure. But it would be not all limited to those rights, right? There would be more that are not included, right?
With what?
The rights you're about to read, it's to my understanding that there's more than just those rights. I was just making it on the record that
start with rights, and there's actually a written version if you want to review it.
well, there's the written version, but there are more rights to that. It's not just limited to those rights.
Those are your constitutional rights, and it's a summary of your
But it's
rights.
not limited to that.
Do you want to review it in writing, or we have it on paper? We have it on the computer.
You can review it, I guess. Yeah.
Okay, so you want the court to read it out loud,
Sure.
rather than review it on
Yes,
in
please.
writing. Okay, let me get to that document.
Observing the opener, the court brands the defendant a sovereign citizen as he immediately claims self-representation. The brief exchange frames a central clash, formal court procedure colliding with an ideological refusal to accept counsel or routine legal norms. The judge's measured language contrasts with the defendant's defiant certainty, producing a concise but powerful hook that establishes conflict, stakes, and the procedural awkwardness that defines the rest of the segment.
So you have the right to be represented by an attorney of your own choosing at all proceedings. And if it's determined you cannot afford an attorney after screening, you'll be appointed one if you want one. If you don't waive your right to an attorney, even if you don't have one at arraignment, you don't waive your right to a later proceeding having counsel. You're presumed innocent of any charges until it's proven beyond a reasonable doubt. The city has the burden of that. You have the right to have a speedy trial. Out of custody, your trial is set within 90 days of the date of this arraignment. You have the right to a jury trial unless you give up specifically that right by signing a jury trial waiver. And you have, if you do want to waive your right to a jury trial, then it would be set before a judge without a jury. You have the right to see, hear, and question all witnesses who testify against you, and you have the right to call witnesses on your own behalf. If they don't come voluntarily, the court can compel their appearance to testify. You have the right to testify on your own behalf. You also have the right to remain silent, not give testimony, or present any evidence in your defense. Your silence cannot be used against you. And then if you feel you cannot have a fair trial because of bias or prejudice of a particular judge, you have the right to ask for a different judge within 10 days of the actual notice of assignment to that judge. That would be for a trial. You're only entitled to one change of judge. If it does go to trial, you have the right to appeal if there's a finding of guilt following the trial by judge or jury. And to begin the appeal, you must file a written notice of appeal in this court within 30 days of judgment. If you plead guilty, you give up all these rights. You're sentenced based upon the facts contained in the police report, and there's no appeal of that sentence. If you're not a United States citizen, a conviction may impact you in your future, and also you may face immigration consequences, including deportation or exclusion or denial of naturalization. Do you have any questions about these rights?
No.
If you'll go ahead and sign that, we'll make sure you get a copy of it. Would you like to hear the police report read out loud for a determination of probable cause? Is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Does the city have sworn testimony to support probable cause in these charges?
Yes, Your Honor. I'm reading from Officer Bayrat Liz Aragad Sandoval. I butchered the last name. On 8/18/2025 at approximately 0328 hours, I was on routine patrol in the downtown area. I saw a black VW Jetta with Washington plate BKL0099 switching lanes multiple times. I ran the plate on my MDT and it showed that the registration was expired. I activated my lights. The driver, later identified as Colton Waslow, kept driving for several seconds. He pulled into an alley on the 600 block of East Chestnut Street. I approached the vehicle. The driver cracked the window about an inch. I informed the driver I pulled him over for his registration being expired. Colton Waslow stated that his registration was not expired. I advised him that DOL was showing his registration expired in June of 2025. I asked the driver for his documentation. Colton Washoe stated all his documents, including his driver's license, were in the trunk of the car. I asked Colton Washoe to tell me his name, date of birth. He claimed it was Colton James. He asked if I wanted his family name. I replied multiple times that I needed his name the way it appears on his driver's license. He said that is how it shows. I ran his name through dispatch and it came back with no results. Officers ran the registered owner of the vehicle, Crystal Bennett Burgess, through Longarm. She showed history with a Colton Washlow. Officers ran the name through DOL and matched the photo to the person driving. I ran Colton Washlow's name through dispatch once more. Dispatch advised that Colton Washlow's license was suspended in the 3rd degree. Due to Colton Washlow's driving with a suspended license in the 3rd degree, due to Colton Washlow's driving while suspended in the 3rd degree, public cause existed for his arrest. I informed Colton Washlow that he was driving suspended and I needed him to step out of the vehicle. He got out and I placed him in handcuffs with no incident. I checked the cuffs for fit and double locked them so they would not close around his wrists. I searched Colton Washlow, incident to arrest, found his driver's license in his left pocket. I read Colton Washlow his constitutional rights from my department-issued Miranda card. I cited Colton Washlow for driving suspended license, for driving suspended license 3rd for driving on a suspended license. I cited Colton Washlow for making false statements to a public servant. Colton Washlow was not forthcoming with his name when told he needed to provide law enforcement with his identity on a traffic stop. After asking Colton Washlow multiple times for his driver's license, he pretended not to know what I was asking and ultimately provided the name Colton James. When asked if that was the way his name showed on his driver's license, he kept saying he was not in commerce. He claimed that he did not know how his name would show in our system. Colton Washlow kept stating his family name was different than what he gave me multiple times. Due to Colton Washlow's claiming his driver's license was in the trunk of his car when it was actually in his pocket and providing a different name than the one on his driver's license after being asked several times if it matched his identification, Colton Washlow, knowing his license was suspended, it is reasonable to believe that Colton Washlow was purposefully not providing his legal name for the purpose of misleading officers. This occurred in the city of Bellingham, state of Washington.
Anything further on the sworn testimony?
No.
The court finds probable cause is established for these 2 charges to go forward. Would you like to enter pleas at this time?
No.
Well,
Thank
it's
you.
either guilty or not guilty.
I'm innocent.
Not guilty pleas are entered on your behalf,
Well, then,
preserving all of your defenses.
I mean, if you're going to enter a non-guilty plea on my behalf, then if you think I'm not guilty, then I'm not guilty and we're good. It's just...
When the judge reads constitutional rights, the defendant pushes back, challenging their scope and suggesting they are incomplete. This exchange exposes friction between rote courtroom formality and an ideological stance that reframes legal language rather than simple confusion. The defendant's resistance functions as principled defiance, forcing the court to reiterate and reassert formal boundaries. The moment deepens tension and foreshadows procedural clashes.
Do you want to be heard on release?
Ask that Mr. Waslow be released on his personal recognizance.
I can entertain it.
Not guilty pleas mean you preserve all your defenses. If you want to bring motions, that's up to you.
I'd like the motion for dismissal.
You need to follow all of the criminal rules of law. If you don't want an attorney to assist you with that, then it's on you to
Well,
research.
I didn't give a plea. I'm not going to plea in the court today. I don't want to be any part of this.
The court's entered a not guilty plea on your behalf,
So then
both
I'm-
charges.
So then it's over. We're good. We're good.
You're released on your personal recognizance. Conditions of release, please conduct yourself lawfully. Don't pick up any new criminal charges while released on these. Do not drive without a valid license, proof of insurance, part of lawful behavior. And your presence is required at your next court hearing, which is a pretrial that's set for October 10 at 1:30.
Yeah, I don't understand. If you're able to enter in a plea for me, then I shouldn't have another court date.
Yeah, well, that's not how it works. The plea just preserves all your defenses. It's not a finding. And there's no final adjudication of not guilty here.
Like, but the rights that I have that you read out.
Would
said
you
that
like to
I-
apply for a public defender to help you?
I'm just wondering why the rights that you had said and had read out said that I'm presumed innocent until proven guilty. Why would I have to enter a not guilty or guilty plea if I'm innocent until proven guilty by that statement?
Sir, I'm not going to argue with you.
I'm just asking for clarification.
Clarification is you have entered, or the court on your behalf has entered not guilty pleas because you don't wish to plead guilty,
So then it's been
which
dismissed.
preserves all your defenses, and you need to then, the city needs to then prove the elements of the crime in order to have a finding of guilt, or if they can't prove it, not guilt.
But if the court puts.
Sir, I'm not
my
going to argue
guilt-
with you.
I'm
I've
not- I'm just
clarified.
trying to clarify.
Your pretrial release order is ready for your review and signature. Would you like the documents printed, emailed, or both?
I do not wish to contract with the court.
Emailed, printed, or both?
You do whatever you would like, but
No,
I'm not
I'm
gonna
asking
sign
you. Do you
anything.
want them printed, emailed, or both?
I'm not gonna sign.
If you're not signing, then I have to take you into custody and set a bail amount. So it's easy if you want to sign. You're not giving up any of your defenses.
Well, but you're entering in a plea for me when I'm still not understanding what's, if you, the court, say that I'm not guilty.
No, what I said is I'm entering a not guilty plea. I'm not finding you not guilty.
Okay, but why not just put down innocent? I'm not pleading.
Here, I'll put down innocent on the bottom, that you're asserting that you're innocent of these charges. If you
Okay.
can get out of the signing part, please. Okay. I've put that information in the form for your review. And now it's ready for your signature. And once it's signed, would you like it printed, emailed,
please.
or both?
Yes, please.
Yes would be both.
Yes.
Okay. You're also being provided the essential elements of the crime. Crimes. So first, Madam Clerk is printing these up. Here's one more. And then she'll also email them to you.
Cool, thank you.
Once you have your paper copies from the officer, you're free to go.
Thank you.
Thank you.
Officer's sworn testimony serves as the evidentiary backbone. Expired registration observed. Repeated lane changes, an alley stop, and conflicting statements about identification. Each precise detail accumulates into probable cause. The officer's measured delivery converts routine observations into credible evidence, making the narrative persuasive rather than theatrical. This methodical assembly of facts is quietly damning and central to the prosecution's case.
Your cases.
Going to trial.
Okay, we already have the matter set for trial, Madam Clerk.
Yep.
Yeah, we have you set for the, on the February 24th trial docket. So what we'll do, we'll bring you back for a trial management on February the 6th at 9:30, and that will be the plea and discovery cutoff. Basically, you and Mr. Patterson will have your last, not preliminary, but last plea negotiations, and if the case isn't resolved, we'll select your jury on the 24th, Mr. Davis. All right, take care. We'll see you then, sir.
Sir.
Mr. Way?
Good afternoon, Your Honor.
Good afternoon, Mr. Williams. This is Mr. Henry Davis.
Yes, sir. We have two case numbers, 24 CF 42 and 24 CF 59. Your
All
Honor.
right, tell me what's been going on with Mr. Davis's case.
Your Honor, I had plans to see Mr. Davis this weekend down in Franklin, and I had a little automobile problem, wasn't able to see him. I have Thursday, he's on my calendar for Thursday for me to visit him. And it's really to go over those medical records that he has expressed a concern about before. And and I've also initiated with some conversations with Mr. Patterson. And he has a few little details he has to take care of before we can really get involved in any possible negotiations. So if we could have one more pretrial conference. I understand we don't have we don't have a trial date, or you don't have a trial date until May, I believe. So if we could come back sometime before that, so we can let you know if we're going to be able to resolve it or continue and go to trial.
All right, let's go ahead and place Mr. Davis on the May trial date. He's been in custody for a very long time. That will be May 19th. But let's come back April 1st at 1:30 to see where we are after your meeting. And I believe you said on Thursday, 2 days from now?
That's correct, Your Honor.
All right, perfect. So I know you have a meeting on Thursday. We'll see you April 1st at 1:30.
Very well. And I assume Mr. Davis is still going to be in Franklin County Jail there. So that's where I'm planning on meeting him.
I'm being told, yes, Mr. Davis will be in Franklin County.
I thought so. Okay, thank you, Your Honor. And that's the only matter I have before you, if I could be excused.
You may be excused. Thank you, Mr. Williams.
Thank you, sir.
Mr. Williams? How you doing, sir?
Got Henry Davis, Your Honor, two case numbers, 24 CF 42 and 24 CF 59.
All right, Mr. Davis, how you doing, sir?
Your Honor, we're presently set for trial on May the 19th. I've had a chance to meet with my client, the investigator has as well, and has some discussions with Mr. Patterson. So I still hold out hope that we may come to a resolution.
Absolutely.
So, and I'm not sure about the status of the 5/19 date. I'm sure you're aware of that. So I
Yes, sir.
think best we just leave it there right now.
Absolutely.
If something develops, we come up with a resolution. We know how to get on your docket
Yes, sir.
otherwise.
Let's come back May 8th
May the-
for trial management. And that way we can talk about if there's any last minute plea negotiations or plea offers, any motions in limine or anything we need to discuss. And of course, you can appear by Zoom, Mr. Williams. So that'd be May 8th at 9:30. And
Your Honor, I know Mr. Williams is aware of this, but just so everybody's on the same page, we will be proceeding on 2442 CF first.
That's
okay. Okay.
good to clarify that, but that's what I figured. Yeah.
All right. Thank you, Mr. Williams.
Thank you.
Thank you, Mr. Davis.
Probable cause is established, and then the court enters a not guilty plea on the defendant's behalf while he insists he is innocent. This exchange reveals a critical procedural nuance: an administrative not guilty entry preserves defenses, but is not a judicial finding of innocence. The defendant's misinterpretation produces dramatic irony. The court advances the case while he believes he has been vindicated, heightening confusion and narrative tension about what legal steps actually.
Ready with Mr. Davis? We're going to take a break unless we're ready. Okay.
Thank you, Your Honor. Good morning.
Good morning, sir. How are you?
I'm fine. Better than I appear.
I'm not going to ask what happened.
It was planned, so it wasn't an accident.
Okay.
Your Honor, today we're with State of Florida versus Henry Lee Davis III. Two case numbers, 24 CF 42 and 24 CF 59. Mr. Davis today is going to withdraw his previously entered not guilty plea and plea no contest in case 24 CF 42 to count one, which is felony battery, a third-degree felony punishable by 5 years in Department of Corrections and or a $5,000 fine. He's also going to plead no contest to count 2 in that case to resisting officer without violence, which is a first-degree misdemeanor punishable by 1 year in the county jail and a $1,000 fine. In exchange, he's going to be adjudicated guilty. He will be sentenced to 50 months in the Department of Corrections. If there is any restitution, we're going to reserve on that. We'll set a hearing later. He will receive 434 days jail time credit. It'll be time served on that misdemeanor, which is count 2 of 24 CF 42. He'll provide a DNA sample, forfeit seized items, and the state has agreed to null pros 24 CF 59.
Yes, sir.
And I'll pass that up. And I believe,
Mr. Davis, you'll raise your right hand for me, sir. Did you hear Mr. Williams' announcement about how you're going to resolve your cases?
Yes.
Anyone promise you anything other than what was stated here in open court?
No.
Threatening you, twisting your arm, coercing you in any way to get you to enter this plea?
No.
This is what you want to do to resolve your cases?
Yes, sir.
You know, the influence of any alcohol, drugs, or medication?
I'm on my meds.
Yes, I believe your medication, I want to say helps you in your behavior and ability to think, but it doesn't affect you negatively in your ability to think, correct?
No, sir.
You understand what's going on today?
Yes, sir.
I know you do, you're highly intelligent, but there needs to be a record of it so I can find that your plea is voluntary and intelligent into. Mr. Davis, you're waiving your right to a trial by jury?
Yes, sir.
And you're waiving your right to appeal anything other than a legal sentence?
Yes, sir.
You satisfied Mr. Williams' services?
Yes,
Had
sir.
a sufficient amount of time to speak with him?
Yes, sir.
You need additional time to speak with him about anything?
No, sir.
I know you're a U.S. citizen, but I have to advise you if you are not, by entering this plea, it could subject you to deportation. You understand that?
Yes, sir.
You have any questions about anything?
No, sir.
Mr. Williams?
no, Your Honor.
I believe, I'm sorry, go
We
ahead.
would stipulate that there's no DNA evidence we're aware of that would tend to exonerate or exculpate my client, and we'll waive any formal reading of the cost associated.
Thank you. And Mr. Patterson, I believe you said there's a,
Yes, Your Honor, my office has been in contact with the victim. She is in agreement with this resolution, Your Honor. I do not know at this moment whether she wishes to address the court or be heard, but she is present if she wishes to do so.
all right, ma'am, would you like to be heard before I pronounce sentence?
Yes, sir, I would.
The release signature. Standoff compresses high stakes into a small administrative act. The defendant refuses to sign pretrial paperwork and is warned that refusal could trigger custody and bail. The clerk's calm, procedural language contrasts with the defendant's obstinacy. This clip shows how bureaucratic formalities can become levers for immediate consequences, turning a mundane signature to the difference between temporary freedom and immediate remand. It has real. This brief transition ties up the sovereign citizen segment and pivots to a separate Florida case, functioning as narrative glue and tonal reset. It manages pacing and provides clarity. Viewers understand that the next sequence will involve different facts, counsel dynamics, and stakes. Such editorial beats are critical in courtroom storytelling. They let the audience absorb one arc before the next and frame expectations for forthcoming legal resolution. Henry Davis resolution compresses plea negotiation and sentence into a decisive endpoint. He withdraws earlier not guilty pleas, enters no contest pleas, and receives a calculated sentence with 50 months and for 130 for days credit. This clip shows how legal strategy, waiver decisions, and judicial calculation intersect to produce a binding outcome that reshapes a defendant's life and provides closure to the case. Like the video, please like and subscribe to the channel, and we'll see you in the next video.